Welcome to the Straight Talking Law podcast. Today, Michael Horne and I are talking about something incredibly serious and sensitive. What to do if you're accused of sexual assault, and how a criminal defence solicitor can help. People facing this situation are often scared, confused, and don't know where to turn. So today, I want to focus on the questions real clients usually ask when they first pick up the phone. So, let's start at the beginning. If someone contacts you after an allegation, one of their first questions is usually, "Do I need a solicitor straight away?" They're often unsure whether they should speak to the police first, or whether getting legal advice might make things look worse. So what should someone do immediately after they're accused of a sexual offence? And why is it important not to attend a police interview without legal advice?
John, thank you for that. And those are questions that I hear all so often. And usually I hear them too late. So the people that come to me, they've already spoken to the police, or they've been along for the interview on the basis that I've done nothing wrong, I've got nothing to hide. A question also that people ask me is, well, listen, if I haven't done anything wrong, why would I need a solicitor? And doesn't that make me look more guilty? And the answer to that is absolutely not. In the event that somebody accuses you of a sexual offence, then usually, if it's an offence which is alleged to have happened recently, then the police will come and arrest you. The reason why they do that is they need to secure DNA evidence and they want to get your first reaction to the allegations. They come along with their body-worn cameras on and they record everything. You might make some simple comment like, "I'm sorry," and you don't even know why you're sorry, but that will be held against you. If the police do attend and arrest you, then what you must do is just no comment, everything. Just confirm who you are, your name, etc., so that you're cooperating with the police, but say nothing other than, "I want a solicitor." If you already know of a solicitor that you trust, then you can ask for him or her to be contacted, even if they're not legal aid, provided you can afford to pay for those solicitors. If you can't afford to pay for them, then at the police station you will be given the opportunity to speak to a free and independent solicitor. Lots of people think that the solicitor is a police solicitor. They're not. They are independent, and you can trust them, and you should trust them. But you shouldn't be speaking to the police. So, if you are arrested, you need to keep quiet. Don't say anything until you have spoken to your solicitor. At the police station, the solicitor will have spoken to the police and will get what we call advance disclosure. That's not everything, but they'll just have enough information to be able to assist you in understanding why you're going to be interviewed and pretty much what it's about. How some solicitors deal with those interviews is they just let you answer those questions, or they just give you advice on whether you should answer some or etc. The way I like to deal with it is that I like a written statement with my client. So we get the advanced disclosure, and clearly if it's you that's been arrested, you're going to know a little bit about why you're at the police station. And if that's the case, tell me everything that you know about that, and we will agree what goes into your initial statement. When we then go into the interview, I will then have the opportunity of reading your statement for you. You can see that the whole benefit of having a solicitor there is to control the information that you're disclosing to the police, to make sure that you're answering the questions that are being asked of you and not volunteering information that you don't need to at this stage. So that's if something has happened recently. If something has happened a little bit ago, a little time ago, then the police don't need to secure DNA, then they may contact you and they may ask you to come into the police station for a voluntary interview. I also get asked a lot, surely a voluntary interview is less important than being arrested, and it really isn't. It's the same other than you're not being arrested. Everything else is exactly the same. My advice to you is that you speak with a solicitor and that you interview them. Speak to several until you find one that you think that you can work with and trust. And always tell your solicitor the truth. Even if you've done something, tell the solicitor so that they are forewarned and they'll know what the police are going to know. But you should have a solicitor. What should you say to the police? Nothing. Simple as that. If the police telephone you and they say, "Hello, I'm PC and I want to speak to you about an allegation that's been made. From that moment, everything that you say is going to be recorded. And a significant statement like something along the lines of, "Oh, I knew you were coming," will really go against you quite badly. So if the police do contact you, you need to say, "Thank you," be polite. "Yes, I'm prepared to attend. Who are you, please?" Get their collar number and their contact details, maybe their mobile telephone number and their email address, and tell them that you will speak to a solicitor and that you'll get back in touch with the police. And you can see that this then gives you the opportunity to speak to a solicitor. That solicitor would then speak to the officer and will find out what the officer wants to talk to you about. And then the whole thing can be structured in your best interests. And that's what you need to think about. This is about you and nothing else. And John, those are the messages that I like to pass back to people. And again, I remind everybody, speak to your solicitor before you do anything else. Really, speaking to a solicitor after is sometimes like trying to close the stable door after the horse has bolted, and it can be quite damaging.
Another big issue is fear of the process itself. People often ask, what's going to happen next? They don't know if they'll be arrested, charged, or released. So Michael, can you walk us through, in simple terms, what usually happens after an allegation is made? And connected to that, how long do these types of investigations usually take? Because waiting with no answers can be one of the hardest parts.
John, again, thank you for that question. And that's something, again, that I hear all so often. When an allegation is made, the alleged victim is immediately interviewed by the police. If it's a rape allegation, then swabs and DNA are taken and clothing, etc. And then they take an initial statement from the complainant, from the alleged victim. And on that, if it's a recent allegation, then the police are going to want to attend as quickly as they can, find the alleged perpetrator, and then they will arrest him or her, and they will get the evidence, the DNA, and they will seize as much as they possibly can. If it's historic, the allegation is some time ago, then the police just may contact you over the telephone. It's no less important, it's no less serious, and it's got the same outcomes if you're found guilty, whether you're arrested or whether you're interviewed under caution, of course, but on a voluntary basis. So what happens? You're contacted by the police. At that stage, get the information from the officer and don't make any significant statements. Nothing. Don't say, "I knew you were coming," or "sorry about this," or "oh, goodness." You just simply say, "Yes, my name is," whatever your name might be, and the police will say, "We want to talk to you about an allegation that's been made." You simply say, "Thank you very much indeed. I will get back in touch with you. I'm going to be speaking to a solicitor. Please can I have your name, your collar number, and your contact details," which should be the mobile telephone or an email address. And on that basis, you'll say, "We will be back in touch with you shortly." And then say no more to the police. After that, you're then in the hands of your solicitor. If you are interviewed by the police, then for an allegation of rape, let's say, or a sexual offence, then what will happen is the police will take your initial comments and then they will go back to the investigation stage, where they then interview the complainant again. Only this time it's probably going to be recorded, where the details then are put to the complainant, and she or he are asked to set out in more detail what they say happened. Well, of course, you have been interviewed at this stage, so you've already you've set the foundations of everything that's going to happen next in that initial stage. That's why you need a solicitor. That's why you need to understand fully what the advanced disclosure is, and that's why you need time with a solicitor to discuss what's going on and be prepared for that interview. Lots of people, John, I must be honest, are rushing to get out of the police station, and they're prepared to virtually do anything to do so. You can't be like that. You need to be in the mindset of, actually, I'm here and I need to do the best for myself. And if that means you've got to stay a little bit longer and you've got to work with your solicitor for that time to get the best outcome in that interview, then that's absolutely what you should do. How long does it take? Well, ages. The initial start of this all seems very quick, very upbeat and very positive, and you feel very negative yourself because the police just seem to have all this evidence and the allegation has been made and you think everybody at the police station thinks you're guilty, and so you're going to feel under an awful lot of pressure. After that, when you are released, if you get police bail, then everything will go considerably slower. And you'll think, heavens, what's going on? And that creates a massive amount of anxiety. And of course it will do. You'll be playing over in your mind what was said at the interview. And an advantage of having a solicitor that prepares a witness statement and reads that witness statement out for you at the interview simply means that you have always got a record of what was said. You won't get a record of what you say in police interview if you don't do the statement until such time as you are charged. And then when you are charged, if that happens, you have to wait until quite close to the first court hearing before the police, through the Crown Prosecution Service, release that information. So your memory will be going mad over all that time. Preparing a statement is by far the best thing to do. And as you think about things more after the interview, when the stress is off, considerably off, then you can think, well, actually, I should have added this and I should have added that. And you can speak to your solicitor about then doing an additional statement to fill in those gaps to assist the police in understanding that, in fact, you didn't do these things. That, John, is my advice. After you've been investigated, you could be waiting months and months and months and months to find out what's going on in the investigation. What can happen after that? Well, you'll be given bail dates that you have to return to the police station. And after that, when the bail dates run out and the police are more relaxed in their investigation, they may release you from bail. But that means that you're still under investigation. If they still need bail dates to protect an alleged victim or to stop you going into areas where the police think that it's dangerous for you to be, dangerous for others, or even dangerous for you, then those bail conditions can carry on. A charge decision, which means the police liaising with the Crown Prosecution Service, can take forever, an absolute lifetime, and certainly it can take a year or more as they go through telephone records, as they go through other evidence, dealing with things forensically, looking at DNA, etc. So you could be on bail for a very, very long time indeed before you find out if there's no further action, good result, or you're going to be charged. And in which case, if you're going to be charged, everything starts in the magistrate's court. So your first hearing will be in the magistrates. It may be that you're accused of a crime that is dealt with solely in the magistrates. That's called a summary offence only. Or it may be that the crime that's alleged is something that can be dealt in the magistrates or the Crown Court, which is called either way. Or it could be even more serious than that, meaning that the alleged crime will have to be dealt with in the Crown Court, and that's an indictable only matter. You need your solicitor to be talking about these things and how to plan the strategy of moving through the investigation and then, if charged, through the court process. John, I hope that helps.
Clients also want reassurance about who they're trusting with their future. They often ask, do you deal with cases like mine? How is a sexual offence case different from other criminal cases? With that in mind, what makes sexual offence cases different from other types of criminal defence work?
So what makes a sexual allegation different from normal offences is basically gathering together of the DNA. The police will be following some urgency to get to you to secure that DNA if the allegation is recent. So there will be a flurry of police activity and an emergency to it, and that adds emphasis, and of course that adds fear. So clearly, if you have committed the offence, the DNA will be there. If you haven't committed the offence but you've engaged sexually with somebody, DNA will be there. The police need to gather that information. So there's that urgency from the police, and it is frightening. But after that, The allegations are the same for any criminal offence. The police must investigate, and they must do it impartially. So they receive the complaint, or they arrest or interview the alleged perpetrator, and then they gather the evidence together, and then they assess. They will be liaising with the Crown Prosecution Service over what evidence might be missing, or how strong it might be, or what else they might be doing. But basically, the assessment of the allegation is done in the same way.
Another huge concern is whether they even have a defence. What if it's one person's word against mine? Or what if the accusation is false?
So we're speaking now, John, aren't we, about evidence and allegations and one person's word against the other. And unfortunately, that happens. It can happen especially in historic cases where an allegation is made on such and such a date 5 years ago, this person did this to me. And in which case then it's going to come down to not DNA evidence. It's going to come down then to he said, she said. But it may be that there are corroborating witnesses who saw what happened or were told what happened at the time. And all of those things are gathered by the police, and they do weigh in the balance of evidence. For somebody to be arrested, it's an extremely low level of evidence required. So the police just have to have a reasonable belief that you've committed a crime. For you to be charged with a crime, it only has to be on the balance of probabilities that a tribunal correctly advised would convict, which is really very low level. So you can find yourself in a position that everything that you say right from the very outset is extremely important when it's coming to weighing up the merits of whether there's going to be a charge or whether there is going to be a conviction. So the most important things for anybody is be very careful what you say. Be careful what you say to the police. Be careful what you say in interview. Think carefully. Remember that some of the questions are going to be open-ended. Some of the questions by the police are going to lead you down a road where you may not have thought about the answers. That doesn't mean to say you're going to lie about it, but what it does mean is that you're uncertain of your answers. To be certain of your answers, you need time to think about what's going on. So, can people's words be taken? Oh, absolutely. And if it comes to a test of between a person, A, who made the allegation, and person B, who is accused, the perpetrator, alleged, then when it gets to court, yeah, the jury or the magistrates or the district judge that hears the case is going to be looking at the parties and thinking, well, who do I believe if there isn't any evidence other than he said, she said? So it's extremely important what you say. It's extremely important that you think about it. And it's extremely important that you speak to a solicitor. Absolutely.
Okay, so how do you approach a case where there's no physical evidence and it comes down to credibility? And what kinds of evidence can actually help defend someone? Things like messages, CCTV, or social media.
So John, you've asked me about evidence and what might be available. We've spoken, haven't we, today about DNA. So if a rape happened last night, alleged or not, then DNA is going to be a very, very important aspect of evidence that the police will be after. They'll also want to seize the telephone of the accused and pick up any electronic equipment, email, iPads, etc. And they're going to want to have a look to see what that person has been doing and saying. So that's a case that's alleged now. But if there's a historic matter, they're still going to want the telephone and they're still going to want the iPad, the computer, if it's certainly alleged that there had been contact through the internet. And they're going to want those devices in order to get that evidence. Saying sorry, people do it all of the time. We seem to think that it's the best way to be polite. And you can, I don't know, drop somebody off at home outside and think you might have upset them on the date that you've been on. And you might send a text to say, hey, look, I'm really sorry. And without saying why you're sorry. And if that person is going to lie about you, then they have got a text from you saying you're sorry. And if the allegation is that man touched me in my car or something akin to that, and you've got a text message saying that you're sorry, then you can see how bad that looks. So you need to be careful. Common politeness sometimes can be very, very damaging. It works both ways, of course, with text messaging. I hear quite often nowadays about Snapchat, and they just disappear. So unless you screen save or something like that, Snapchats go. And if you're out on a date with somebody and you are Snapchatting them either before or during the date or directly after, you don't keep your messages, then it may be that your defense has gone, deleted with those messages. It may be, of course, if you are the perpetrator and you have done this thing, then evidence against you goes, well, if that's the case, that's the case. But if you're innocent and you need to rely on messages to show that, in fact, you didn't say the things that were said before the date, or you didn't arrange this or that, then keeping messages is very important. And my advice to everybody, John, is if you are speaking with somebody and you're talking about a sexual engagement of some kind, even with a recent partner, then get off Snap. Go onto a forum that you can keep and save, because everything is about evidence. And even though you might really like the person that you're with, you don't know them. It takes time to know somebody. Keep your evidence. That's what I say.
For many people, the legal case is only part of the fear. They're worried about their job, their family, and their reputation. They'll be questioning, will I lose my job? Will my family find out? Will this stay on my record forever? Michael, what impact can an allegation have on someone's personal and professional life, even before a case is proven?
John, thanks for that question, and you're absolutely right. As soon as somebody makes an allegation, the bomb's gone off, and it's damaging. If you work in the professions, or you work with vulnerable people, or you work with children, then you have to tell your employer. And as soon as you tell your employer, then they're under a duty to act, to protect people, even though nothing is proven against you. These things have to happen. So immediately these allegations are made, you could face suspension straight away from your place of employment. And of course, it doesn't matter how confidential the employers say they're going to keep it. People know, people talk. So already the damage is starting. As far as friends are concerned and family, you'll tell who you want to tell. My advice to you is don't tell anybody. You're going to have your husband or your wife or a close family member, and then mum or dad, brother or sister. And of course, if you trust them absolutely, you can talk to them. Talking to people will help you. And I do understand that, after the busy day and things are quiet at night, that's when the worrying really starts. And to have somebody that you love and trust, that's close, to help you through those evenings, then that's really good. And I think that you should do that. But you have no friends, and you have to remember that. Because everything that you say, either on social media or to a friend, can be used in evidence. So if you're just talking, you say, goodness, I might well have done that, and you say that to a friend, then that friend can give evidence later. Remember, anybody can be called in that regard, in that circumstance, to give evidence. So you have to be extremely careful what you're saying. If you're really, really down about this and you need help from your doctor, you can tell your doctor. But of course, if you make admissions, if you say to the doctor, yeah, I did this, and I'm really worried about it, then your medical records can be called into court and comments can be made. You said this to your doctor, didn't you? Why are you now pleading not guilty? And of course, I'm often asked by people, how do I defend these guilty people? And the answer is, you don't defend guilty people. Every time that a client tells me they didn't do it, they are not guilty. They're not guilty until either they admit it, they accept they've done it, or a court tells us that they've done it. And at which case, obviously, things then change for that person. Obviously, until you've been convicted or you plead guilty, you're innocent. But those collateral damage points, friends, employer, etc., your social environment, job generally, people who you mix with, perhaps the clubs you're involved in, if you're a scout leader or you assist in some way with gymnastics or care of kids after school, etc. All of those things will have to stop. And if the allegations are of a sexual nature, usually the bail conditions from the police are such that you do not interact with underage people. So Yeah, John, you're absolutely right. The damage it starts early. And another reason why you need to speak to a solicitor that understands that, because they will help you navigate through those points.
And what protections exist for someone who hasn't been found guilty?
Well, what protections are there? The police can attend at your home and they arrest you. The allegations are made when you are arrested. They say, we're arresting you on an allegation of. These things can be overheard by family, friends. So it's already started to become available to people that want to talk. And you have to tell your employers. So there are no real protections in that regard. If it is the case that you are then bailed, possibly you can't go back to your own home. If it's an offence against somebody who's underage, you might have children at home, so you're not going to be going home. And people will know that. Social services will become involved. And of course, the school will need to be told. And if those bail conditions are such that you're not allowed to contact the children directly, you might be able to see them with supervision. The children are going to be wondering what's going on. So you can see that a lot of people are going to be speaking about these things. But what will not happen is it is not going to be in the press, even if you are charged. So there's a protection available to everybody involved in allegations such as these until such time as you would be found guilty or plead guilty. And in which case the press may report, but only at sentencing, or if you've pleaded guilty, they may just record, put it into the public domain that you've pleaded guilty to a sexual offence, and in which case it's then in the public domain. So no protections really are afforded other than those for somebody that's accused. The devastation is really very bad indeed, John.
Michael, thank you for explaining that. If someone listening right now is facing an allegation, the most important message is that they should get proper legal advice as soon as possible and not try to handle this alone. This has been a difficult but important conversation, and we hope it helps people understand both their rights and the reality of the process. If you are in need of a solicitor, please do get in touch with our team. Thanks for listening.